Thanks, Anthony. What have we learned? We learned that people are crazy, an Oregon man watched too much Home Alone, and that interesting part about the police cruiser, that kind of ties in a little bit to Jason Van Dyke, because when he was on the stand, he talked about maybe using the car as a way to subdue Laquan McDonald. We'll talk about that in a minute, but again, go to lawandcrime.com if you want to follow the top trending stories of the day. But right now, let's take a step back and focus on the Daniel Villegas case out of Texas. And to help me talk more about it, because you don't want to just hear me, I have a very special guest with me. I have attorney and former judge Ashley Willcott. Ashley, great to have you here on Law&Crime.
Thanks, Jesse. Happy to be here.
Okay, so now this case is a little strange, but I want to talk about the idea how we have a third trial here in the sense that the highest court said, you know what, police coerced this confession, that there was a problem here. Now, correct me if I'm wrong, isn't that very hard to prove and convince an appeals court to overturn a conviction on those grounds?
Yeah, it absolutely is, Jesse, and it's not typical that it's overturned on those grounds. But in this case, they did have the video of the confession that the Court of Appeals was able to consider all of that evidence. And then also the jail phone calls they considered, Jesse. And in looking at all that, they said, look, he was intimidated, he was coerced. Now, keep in mind, at the time this happened and that interview happened, this defendant was only 16. Mm-hmm. So I think the fact that he was a minor played into it as well.
You know, we keep seeing this. Everybody talked about making a murderer. The age of the person who's in that police interview really becomes a question. Ashley, stand by. What I want to do right now is play some testimony from the Daniel Villegas case in case anybody missed it. The first person we're going to play is Jesse Hernandez. This is the victim's friend who witnessed the shooting back in 1993. And imagine what we're talking about. 1993, 2018. Let's talk a little bit more. Let's play some of that testimony right now. Okay, let's bring in Ashley Willcott to talk about this. Now, Ashley, we are listening to testimony, not something that happened last year, 3 years ago, 10 years ago, 25 years ago. What is that like, prosecuting a case where you're talking about a crime from so many years ago?
Right. So typically, often the prosecution has witnesses who either don't remember, aren't emotional. So much time has passed. It's a difficult witness to really convince the jury that their story is credible. But Jesse, I noticed with this witness, he even said my hand shaking as he was trying to show where the car was. So clearly, even though it's been so long, this is a witness who still feels it very emotionally and passionately and is going to be a compelling witness, I think, for the prosecution.
And that makes sense because there are certain events, particularly a shooting, a drive-by shooting, that would stay with the person forever. I mean, there are those moments that stay with individuals. So if he didn't witness the shooting, maybe he wouldn't have felt it so much, but he was right there.
Right, and he uses words like he heard the ping and he saw the glow, and so you can tell that it's still, you know, embedded in his memory that he can remember all the details.
Yeah, absolutely. Now, I do want to let our viewers know that we are probably going to be covering this case on lawandcrime.com, so if you want to follow it, you will probably go there. The reason I say that is because here on the network, we are mostly going to focus on the Jason Van Dyke case. Let's take a quick break. We'll be right back. Stay tuned. A lot to discuss here on Law and Crime. Okay, so Ashley, I'm back here with Ashley Willcott. How are we supposed to reconcile this? We have the defendant saying that Laquan McDonald was advancing towards the police, advancing towards him. It was a threat. When you have these other witnesses who were there, saw the shooting, and said, we never saw any threatening movement on the part of Laquan McDonald. He was merely walking away from police. How are we supposed to reconcile that?
Well, so the jury's going to have to reconcile that, first of all, Jesse, but I think it's really clear. The only possible defense this defendant has to make in this case is that he perceived it as a threat. So, of course, that's his defense. I think it's common sense to say that's his argument. It was a threat to him. I don't believe him, given the other testimony. I find when he testifies to me, he appears very pathetic. I don't believe the defendant. Is the jury going to believe him? Let's find out. But also there's a video, Jesse, so we can't forget that in the video, to me, and I've watched a lot of this trial and a lot of the coverage, it looks like he indeed is walking away from the police. So I think this is a very weak defense that he perceived threat.
Let's play devil's advocate here, right? So there are people who will say that Jason Van Dyke is lying and just saying whatever he needs to do to get, himself acquitted. But here's the thing. Is it fair to say that his perspective, from the angle that he was at, maybe he saw something that no one else saw? Now, we're going to learn later that he said, look, that video that you see, it didn't capture a lot of what was going on. It was a back view of Laquan McDonald. I saw the front view of him. Is that fair? Is that a fair analysis?
Well, it's his perception. It's his belief. It's his description of exactly what happened and what he saw in the defendant's eyes, and that he believed that it was a threat to him. And so, again, it's going to come down to the jury and whether or not they believe his story, and it's enough reasonable doubt to believe that he didn't do it, right? That's what it's going to boil down to.
You know, it's funny. If you told me a week and a half ago, I might have had a different perspective. But then we learned something from the defense's case that officers, we learned it from one of the witnesses, that recruits are taught you are allowed to use deadly force if there's a fleeing felon. So if someone's escaping a crime and they're carrying a deadly weapon, it doesn't necessarily matter if they're a direct threat to someone at that moment. They can open fire. I mean, that's a pretty big statement.
That's a huge statement. So it's what it provides for if it is a convicted felon. But it's a little scary, right? Think about how if they're fleeing from the scene, they can use deadly force is really a little frightening. But having said that, the other piece of this that I think is important is he is carrying a knife. Is it a deadly weapon? Yes, but it's a different type of deadly weapon from a gun. A gun he could shoot from anywhere and hit one of these officers or an innocent bystander. With a knife, he has to be in the proximity. So I also think that's a really important piece in this case. It's a knife. Look at the video just shown. He can't stab them from that many feet away.
Yeah, one of the things we learned is that officers in the Chicago area were told about this weapon that's it's a knife that can shoot a projectile out. But there was no indication from what we've seen that Jason Van Dyke thought that that was that weapon, or even that was in his mindset. I've never heard him say that I thought this was that weapon that could shoot the projectile. But why even introduce that to the jury then?
Well, and that's a good question. Why? Because I did not hear him testify at any point in time that he thought that it was a knife that could do that. In fact, I understood him to say the opposite, which was he was just holding a knife. So why introduce it to the jury? Again, reasonable doubt, because you want to create some reasonable doubt if you're representing the defendant.
Yeah, I mean, we have a lot to discuss here. We're going to be live in that courtroom, but we are going to dissect every inch of Jason Van Dyke's testimony. So stay tuned here on Law and Crime. We're going to take a quick break. When we come back, there is a lot more to discuss. Okay, let's talk more about this with Ashley Willcott. Ashley, is there anything a little strange about the idea that he opened fire at the knife? We know that the prosecution later on really had an issue with that because these officers are not trained to do that. What did you think?
Right. For me personally, yeah, it's an issue because it is a knife. Again, the proximity of the person to you makes all the difference in the world as to whether or not that can be a deadly instrument. A gun, you can shoot someone far away. A knife, you've got to be right there to stab them. So his testimony does focus on the fact that the defendant never dropped the knife, but we still have to think about, does that mean the defendant was an immediate threat to this particular officer? The other thing, Jesse, I can't help but mention is throughout his testimony, he talks about the defendant's eyes, and his eyes were bugged out, and there was nothing there. And so I think that he focuses a lot on the defendant's face and eyes and the knife. But it's a knife. It's different than if the defendant had a gun. That's where I stand.
Okay, but the idea, and let's talk about this. What happens if he was mistaken? He said he saw the knife cross Laquan McDonald's shoulder towards where the officers were. What happens if it wasn't really the knife? Maybe it was a reflection of something else. What happens if he just made a mistake? Where are we left with if that's the case?
Well, I think even if he made a mistake, you have to think about, was it a threat in his mind? I mean, that's the standard, right? And so I guess I hadn't thought about what if he made a mistake and he wasn't holding the knife or didn't have the knife, because by all accounts and all testimony, he was holding a knife. But it still goes to what the threat was in the officer's mind. Was there an immediate threat that he had to defend himself against as an officer? Absolutely.
Let's talk more about the use of force, though. So you heard what the defendant said. I want to play the testimony of Uri Patrick, who's a use of force expert brought onto the stand earlier in this case. Do want to let our viewers know, though, that we are going to be live in that courtroom today. We expect closing arguments actually tomorrow, so there's more needs to be brought out in evidence today. Let's go to Uri Patrick right now, and this is a use of force expert. Well, that's not exactly the clip that we wanted to play. We'll play that a little bit later. I want to bring back on Ashley Willcott. So, Ashley, what we were going to play was the defense's use of force expert, and you have two competing views here. One says justified, one says not. What is a jury supposed to do when you have two qualified experts giving two radically different opinions?
Well, unfortunately, the worst case is it's a mistrial, right? They can't come to a unanimous decision because of the two experts having differing opinions. On the other hand, it's their responsibility to really determine which one's credible and which one do they believe is the right expert, so to speak. And one of the language in the first expert you just showed clips from, when they said avoidance behavior and talked about the fact he was walking away. And I think that in conjunction with the video that shows that, at least the piece of the video we see, is very compelling evidence.
Yeah, I mean, having video evidence of what ultimately happened, that's the strongest evidence a jury can have. I mean, even if the defendant comes on the stand and says, this is what I viewed, a video doesn't lie, right?
Yeah, I think it's pretty damning. So a picture's worth 1,000 words. As a judge, when I see cases come before me and you have pictures or videos, it makes a significant difference because regardless of what a defendant or person says, this is what I perceived, you see right here exactly one perspective of what was actually going on.
But he's charged with murder here. So the other instances, this is a radically different case than the other cases that we cover. So in other words, do any of the jurors realistically believe that he woke up that morning, Jason Van Dyke, and wanted to kill someone? I mean, that's really what we have to, I mean, woke up, or even at that very moment, he wanted to murder this man, or was he simply trying to protect him and his fellow officers? I mean, isn't this, we have to really think about this?
Well, the motive doesn't matter. So I don't think it matters whether he intended it when he woke up in the morning or not. I don't think he at all thought he would kill someone. I don't think that his goal was to wake up and say, I'm going to kill this man today or kill someone today. I completely believe that he overreacted, that he reacted by pulling out his gun and shooting and shooting and shooting and using inappropriate deadly force, and that amounts to murder.
Yeah, I mean, there's a reason this is at trial, because these questions need to be answered. Now, what we're going to do is we're going to take a quick break, but when we come back, there's a lot more to discuss. Yes, we'll play Jason Van Dyke testimony, but we're also going to hear the testimony from a psychologist. We'll be right back, right after this. Okay, so this psychologist came on the stand yesterday. We saw a lot of analysis about the brain development and things of that nature, and then we finally got that conclusion, which is what we were waiting for, back here with Ashley Willcott. So the defense brought out the psychologist. How much does it value? How much will the jury value what this psychologist ultimately, his determination was?
I think they are going to put a lot of value on it because he specifically testified, and I wrote down the words, that the defendant had a perceived deadly threat and that he then responded in a way appropriate to that. That's huge for the defense. And you have an expert who, at least when I listened to his testimony, I found him credible, believable. He was qualified, right? They got all the qualifications out to make sure he qualified as the appropriate expert. So I think the jury's going to put weight in that. However, I have to say this, devil's advocate, I still think the video is going to outweigh this testimony.
You know, we have a long way to go. We still have another day here, more witnesses probably, and then closing arguments, and then the jury deliberations. But let's talk about outcomes here. If there's a mistrial, what's going to happen? Is this one of those cases the prosecution will definitely try again?
I think they will. I don't think there's any compelling reason not to try it again, especially with the public involvement and how much media attention's been garnered on this case and the fact that it's law enforcement, right? The people that we trust to protect us. I think the people see the video and perceive that he didn't protect, that he actually murdered someone. So I absolutely believe if there's a mistrial, they're going to try this case again.
Okay, well, now we actually have our video, what I wanted to play earlier. This is Barry Broad, the use of force expert for the defense. So you're seeing these competing narratives both by the prosecution and the defense. Prosecution's use of force expert said the shooting was not justified. Let's see what the defense's expert had to say. All right, Ashley, you saw that. Are you ever amazed at how you have two experts? This is their field. This is their specialty. And you have two radically different views about the same event. Are you ever surprised by that?
I see it a lot as a judge. So that's the nature of the game, right? The litigation game. And that is each is going to have their own expert and they're going to disagree. So I see it frequently. One of the things that I think distinguishes these two experts in their testimony, Jesse, and I've written down again so I don't misquote, this one really focused on the 12 to 14 feet and the amount of time that it would take for the defendant to get with a knife to the officer and actually pose the deadly threat or hurt him. And he testified it would only be 1.5 seconds to 1.7 seconds. And so I think that was the focus of his testimony, and the other expert for the prosecution did not focus on that time frame. So I think often jurors need to look at expert testimony as looking at two different aspects, so to speak, of their focus as an expert.
And it's really up to the jury to decide one way or another. I wonder, we talked about what would happen if there's a mistrial. What would happen if it's determined that the jury comes back eventually when their deliberations are done and they say that Jason Van Dyke is not guilty? What is the outcome of that?
Outrage. I mean, as we all know, double jeopardy attaches. So the prosecution can't try the case again. They can't retry these particular charges against this defendant. I think if it's a not guilty verdict, we are going to see a lot of public outcry and a lot of public reaction.
Do you think the police force, if this is determined a justified shooting, will view their use of force differently moving forward? And we only have about 20 seconds.
I don't think so. I think it's an outlier, and I think that it's still going to focus on the actual officer's perception.
All right. Well, we have a lot to discuss in this case, and I'll tell you right now, I have no idea which way this case will go. We are seeing strong evidence both by the defense and the prosecution. So we will take a quick break, but before we do, here is a short segment, a short preview of a special on the Jessica Chambers case. Take a look. All right, we're not exactly sure what was happening yet in the courtroom. We believe the judge was yelling at the defense attorneys there. Back here with Ashley Willcott. Ashley, I don't know if you saw what was going on or knew anything. I didn't see anything, but the relationship between the judge and the attorneys is a delicate one, isn't it?
Well, so the judge's role, as we all know, is to manage the courtroom and make certain that the facts are that the laws apply to the facts, right, and that they follow all the rules of evidence and do everything correctly and make those rulings. And so, to me, I couldn't hear what was being said. It looked like the attorneys were being dressed down by the judge, and quite frankly, the judge has that discretion and responsibility if it's necessary to ensure that the attorneys are acting properly in the case.
And you always want to make sure the jury's not present because they don't want to see this. They don't want to feel that the judge is going one way or another because that might influence their ultimate decision. All right, so we played you a little bit before of Jason Van Dyke talking about perspective. We understand that his perspective of the shooting is different than the dash cam video of the perspective from the dash cam video. But let's play the testimony of Paul Reddit, a forensic video examiner from the FBI, who can talk more about this perspective and what is seen and what is not seen. Okay, so that's some discussion about the different perspectives of the shooting, but I want to talk about what just happened live in court. We saw that the judge was yelling at the attorneys, and it is relation to some witnesses that will be called. The defense wanted the prosecution to present an offer of proof from prosecutors on at least one of the witnesses. This is to make them show why the testimony will be proper or relevant. And the judge apparently got irritated that this was not a request in writing. The defense combated back and said, hey, listen, the prosecution never put it in writing. I'm back here with Ashley Willcott, and you tell me, who's right on this argument, and why does this matter?
Well, so here's what should happen. There should have been witness lists provided to each side prior to trial, along with what the witnesses would be expected to testify to. If that happened, then a judge is going to expect any written motions contesting witnesses or asking for an offer of proof. So that might be why the judge is now saying, why wasn't it in writing? Now, if that didn't happen and the defense didn't know of this witness or just learned of this witness, they wouldn't have had the opportunity to put it in writing. So I think there are a lot of legal aspects at work here and trial skills and what's supposed to be done and not done. Now, the relevance importance of it is the defense is clearly now saying we don't know why this witness is relevant, why this witness is being called. We need to know that so we can make any appropriate motions.
Because the prosecution's probably putting in these rebuttal witnesses that might hurt the defense's case ultimately. So we're going to have to see what happens. I want to switch gears and go back to the testimony of Jason Van Dyke. Where we last left off, he's going to explain how many shots he fired the second time, and we'll analyze it. So here's some of his testimony. All right, the number of shots fired by Jason Van Dyke is critical in this case. We keep seeing discussion about it. Let's learn a little bit more from the defendant about when he stopped shooting. Take a look.
Rephrase it.
Sure. Did you ever make a decision?
It happened consistently, that it matters how many shots he fired, which one was the fatal shot. Some people are looking at this, though, and say, hey, wait, we know who did the shooting. We know he killed him. Why does it matter if he was 16 shots in him or one shot was the fatal one? Why does this matter?
Because, again, it goes to the threat and the perceived threat by the officer. If you have 1 or 2 shots, and he just testified, I think I fired 2 or 3 shots, yet the defendant was shot 16 times, there are a couple of different arguments to be made. One is the perceived threat. To shoot 16 times is overkill. I hate to say it that way, but it's overkill. And the other is a possible argument, not saying the defense is going to make it, but they might want to argue, hey, there were more shots fired by someone else than our defendant. I don't think that's the case, but I'm just saying that's why all of those things are important in terms of forensic evidence.
And he also said, I wasn't even sure I was hitting anything, I just was firing. At the end of the day, do you think it was a good idea to put him on the stand?
I think they had to, because, again, it goes to his state of mind. The perceived threat he had. I don't think they had a choice, given this is the defense.
And we'll talk a little bit more about how you thought he ultimately did, because we're still dissecting his testimony in its entirety. Let's play a little bit more from the defendant about when he stopped firing. Now I can ask Ashley my question. You saw him be a little combative with the prosecution. He was a little stumped, what appeared to be stumped, by the question of shooting at the knife. How do you think he did on the stand so far?
I think he was too defensive with the prosecution. With the prosecution, yes, when they were cross-examining. Sorry about that. So he was very defensive, and I think that posture to me indicates that he is very, like you said, combative, and I don't think that that's good for him in his testimony. The other thing, he just said, I was focused on getting that knife out of his hand. That to me is not the same as I was focused on the immediate threat. I don't know. I don't believe him myself. I don't.
You're saying his stories are changing. That was a big criticism, that his story kept changing from when he first told it right after the shooting to now.
Yeah, I absolutely agree. He was very clear in the first shooting. He was approaching me, he was coming up to me, and then, or the first story. And then once he saw the video and heard all the other evidence, to me, he has changed his story. I think he's trying to appear very remorseful on the stand, but I also, to me, think it comes across as somewhat pathetic, and that he shot someone with deadly force that he should not have shot.
Is there any argument that, hey, listen, once I had the minute to sit down, recall the facts, yes, my testimony changed, yes, my account of the facts changed. I mean, at one point he's staring directly into space as he's on the stand explaining what happened. So maybe is someone's perspective very different at the event than it is weeks, months, years later?
Always. I think that's always the case, right? And so your memory changes and you hear different things, and I think that's natural. But if that's the case, I think his attorneys have the opportunity and responsibility to make that clear to the jury so that it makes sense to the jury and is plausible.
Okay. Well, I'll tell you what, we are also not just analyzing his testimony. We're analyzing it in relation to other people who testified and other evidence that was brought in to try to see, is he telling the truth? We're going to do that when we come back with more of his testimony and other witnesses. Stay tuned here on Law and Crime. Okay, so you have two different perspectives from two different officers that night. One, the defendant who opened fire, and from one of the witnesses who did not open fire. Back here with Ashley Willcott. So if one of the officers, and there were a bunch in the area, we know that this officer was following in the car right behind. If one officer, just one, had opened fire, one shot, would this have been a radically different case?
I think so, because clearly there would have been more than one officer, the defendant in this case, who believed this person to be a threat, right? So I do think it would have been a radically different case. But take that in conjunction with the testimony that you just played, Jesse, and that is, not only did he not fire a shot, he did not feel that it was a threat, that it was under control, that the defendant was walking away from him and the situation was under control.
Yeah, I'm watching the video again, and I'm trying to see what Van Dyke might have been seeing. The knife moving across the shoulder of Laquan McDonald. I don't quite see it from this perspective. Then again, the whole idea about perspective is interesting, right? We talked about it earlier. This perspective is radically different than the perspectives of the officers. Would you agree that a video doesn't tell the whole story, even though here it kind of tells a lot?
It tells a lot, but it doesn't tell a whole story. So the video you just showed, you see officers at different places along the road. All of those officers necessarily have different perspectives that cannot be shown by one video. So there's absolutely more to the story that we don't know. Devil's advocate, Van Dyke may have felt like, oh my God, I can see him. He's got a knife. He's bringing it across. He can get to me. He's going to kill me, and shot him.
Now, we hope that this jury is impartial in the sense that they came in with an open mind or just waiting to make their decision based upon what's presented in court. But how difficult, in your experience, is it for a jury to convict a former police officer?
Well, I do think that they come in impartial. I think I came in impartial starting watch all this evidence. Whether or not it's a former police officer, I don't think makes a difference in terms of the actions other than the standards, right, that apply to him. I'm not concerned about that biasing, so to speak, the jury.
Yeah, and at the end of the day, he's a human being. He makes a mistake. Everybody does things that are wrong, you know, and I think him on the stand, correct me, showing that agitation and going into that combative nature with the prosecution, that doesn't help him. It shows him to be not this professional officer that he would hope to be portrayed as.
And that's exactly what I think too, Jesse. And I think that the reality is he reacted. He reacted to a situation. He reacted in a way that he probably feels was appropriate. I don't think that it was, but he reacted, and he's human. But I don't think he is necessarily representative of the police officers that I know and work with every day.
That's a fair assessment right there. When we come back, we're going to have more to discuss in Jason Van Dyke, including some excitement in the courtroom from today. Stay tuned. Okay, so that was from earlier today where the judge was not too happy with the defense for not putting that request in writing. But I got to ask Ashley Willcott, attorney and former judge, about something. Ashley, just between you, me, and all of our viewers, is there a certain joy that a judge gets from really talking down to attorneys that think they know it all and having to instruct them, this is what really the matter is? Is there a little bit of enjoyment there?
I don't know if it's enjoyment, but it's certainly frustration. So I actually still serve on the bench to fill in. And here's what happens is you sit and you listen to so much. And sometimes when attorneys do things that they should or shouldn't, you just get frustrated. You're a person. And so I don't know that it's joy, but it's certainly a frustration in saying you should have put it in writing. If you figured out last night, file a motion. But I'm also going to say judges have to be really careful, right? They can't let that frustration get in the way of what's good for the goose is good for the gander. You've got to apply the exact same rules to the prosecution and defense.
Sounds like it's a little enjoyable. It sounds like it's a little enjoyable.
Maybe a little.
So that was from this morning. A little excitement there in the courtroom. The judge and the attorneys are meeting right now. As soon as there's a feed back in the courtroom, we're going to make sure to go there. But in the meantime, let's play some more testimony that you may have missed. I want to play Dr. Lawrence Miller. This was a psychologist brought forward by the defense to talk about what was going on in the mind of Jason Van Dyke and whether or not he actually perceived a threat. This is some testimony from yesterday. Okay, so we focused the beginning part of our program on the actions of Jason Van Dyke, but now we're talking a little bit more about Laquan McDonald. You heard Dr. Lawrence Miller talking about how if someone is intoxicated, does that increase the violent nature of the person? And here you're talking about with the medical examiner about the drug use. So I'm back here with Ashley Willcott to talk about it. Now, this is a tricky scenario, trying to not cast blame, but yes, I think that is what the defense would ultimately be doing, casting blame on the victim here. The first part they're talking about is him being on drugs and in this state. Does the jury hold on to that? You know, how important is this argument to talk about what was going on in his system?
Well, here's why I think it's important, because they can tie that directly to the defendant's own testimony that he could look in his eyes and they were dead and there was nothing going on, and that increased the level perceived threat to the officer and his perception of the threat. So I think they can connect those two. And it is a bigger threat if you have somebody who perhaps is on illegal substances or drugs or out of their mind or in a different state of mind. They may do something that they wouldn't otherwise do. Because
it creates an unpredictability, correct?
Sure.
And I guess the other thing, too, is, as you just said, it's not just to show his state of mind, but if he was on this substance and you hear Jason Van Dyke say he had a blank stare in his face, doesn't it add credibility to Van Dyke's story?
100%. And it does make it then sound like, at least if I were a jury, I would think, wow, he really was a threat to this defendant because he was out of his mind or he was in an altered state. And that needs to be taken into account because, again, the crux of the case is, was it a threat to Van Dyke, to that specific officer who then shot him?
Right, exactly. Now, this is a tricky scenario trying to really cast blame on the victim, a 17-year-old who was gunned down here. But that's what we're going to learn right now from some more testimony. There was a discussion brought in about the criminality of Laquan McDonald, not so much at that right moment, but in the time before, in the past, and what was he like in the past and his violent nature. Let's learn a little bit about it. Okay, we're learning about the criminality, the violent behavior of Laquan McDonald in the past. But does that matter right now? Ashley, what do you think? Does it really matter what he was like in a past instance? I mean, we're talking about the shooting at that very moment, no?
Sure. Well, it shouldn't matter, but here's how it does. It's the likelihood that he is going to commit a crime, commit an offense, or be aggressive or likely to do it to this officer. Again, it goes to whether or not the officer had a real threat perceived by him from this particular individual.
Yeah, I mean, but people change. I mean, they could be angry one instance, they could be violent another instance, and, you know, maybe, but then again, we do have him walking on the street holding a knife. I mean, so again, is this a distraction, and does the jury will not like to see that?
Well, I do think it's a distraction. I think it's an outlier in this case for this reason, because what he's done in his past has nothing to do with whether or not it was a very real threat that caused the officer to shoot him without it being a crime, or whether it was an actual murder of the defendant. So in the end, at the end of the day, I don't think it matters. I also think the public's not going to want to hear that, like you said, you can blame a defendant for getting shot by a cop.
And Jason Van Dyke didn't know Laquan McDonald before the shooting, so it's not like he was familiar with his record and his violent tendencies.
Absolutely. And it wouldn't, right? He'd have no idea what that was and whether or not he's likely to do it or not likely to do it. So at the end of the day, I think it's an outlier that's not going, I don't think the jury's going to pay a lot of attention to that evidence.
Yeah, there's some strong points that are put forward by the prosecution. The taser unit in the area that could have put Laquan McDonald down. No other people, no other civilians in the area. Him walking away from the officers. I mean, these are really big points that the defense may have trouble arguing away. We're going to take a quick break on our end, and when we come back, we'll talk more about this case as well as a new case out of Texas, the Daniel Villegas case. So we're covering a lot here, and we are waiting to be live in Jason Van Dyke. Stay tuned here on Law and Crime.
Here are today's top crime stories trending on Law&Crime.com and across the country. A man in Oregon is under arrest after he allegedly rigged his property with elaborate booby traps that left one FBI special agent with a gunshot wound. Authorities went to the home of 66-year-old Gregory Rodvelt at the request of his real estate lawyer, who told officers a sign was posted on the property warning it was protected by improvised devices. Investigators went through the property, avoiding such Indiana Jones-inspired traps as a minivan outfitted with spring-loaded animal snares, a hot tub with a tripwire set to trap a trespasser, and a wheelchair rigged with shotgun ammunition and set to explode if moved. That last booby trap injured an FBI agent, leaving him with a non-life-threatening gunshot wound to the leg. Rodvelt now faces one count of assault on a federal officer. Dashcam video caught the moments when a Boston police officer rammed an alleged moped thief with his cruiser. The suspect reportedly stole the scooter in the Seaport area of Boston before he was rammed by the officer. Authorities claim the man was getting ready to steal another moped. Boston police have launched an internal review of the manor, and the young suspect remains at large. Two people in Florida are facing charges after they were caught on camera beating up 4 people, including a child, at a gas station. The suspects, 18-year-old Brandon Clanton and Julia Marie Napiontek, were arrested after the unprovoked attack on 4 victims, including an 11-year-old girl at a Circle K gas station in Silver Springs. Clanton and Napiontek now face charges of battery and aggravated child abuse. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Did anyone notice that guy right in the video of the beatdown was just drinking his coffee and walked away? I guess it doesn't matter to most people. I don't know. Ashley, I have to sign you off soon, so I just want to ask your final thoughts on Daniel Villegas, because this is a really, really interesting case.
It's a really interesting case. So again, we're seeing in a series of cases that Law&Crime's been covering in trials, time number three, let's see what's going to happen. But keep in mind, this man has not been in jail. He's been out of jail for 20 plus years now and is now being tried again. So we don't know how well the witnesses are really going to be able to provide the compelling testimony to convince him beyond a reasonable doubt.
And he refused to take a plea deal, wants to take this up to the jury, so we'll see. Ashley Willcott, thank you so much for coming on today.
Thank you, Jesse. Have a great one.
All right, everybody, we're taking a quick break. We'll be back. A lot to discuss here on Law and Crime.